Yo, the U.S. Constitution is the source of judicial force, and our courts ensure for sure. Importantly, Article 3 sort of speaks one Supreme Court in a being, and courts beneath that, which Congress establishes, whose judges can last in the judiciary until they pass. Oh yes, well that's implicit, it's not stated in fact, but if they get to tripping and start behaving bad, that's their ass. Yes. May I add, they shall have the power in all cases arising under the Constitution now, and laws of the U.S. and treaties in other areas are stated here briefly. Cases between the U.S. states and the people, the states and each other, the U.S. government, maritime crap, and if the case involves ambassadors, it's in the latter, or when the states involved in matters, SCOTUS has which is known as original jurisdiction, yo, meaning those cases directly go to SCOTUS at the trial stage. Everything else that we just spoke of can't be filed in the Supreme Court. It's an appellate court, because trials in those other courts to be established by Congress. As said before, there's other language about crimes that we're gonna ignore here in this article compared to all the stuff written previous in 1 or 2. Article 3 maybe the lenience when you read it. A lot of it's undefined and left to Congress to establish. Man, wanna know why? Truth is that there was dispute over whether the Constitution here should have a national institution for our judiciary. States are very scared about federal tyranny. Don't believe or just peep the amendments for the way, all of which deal with judicial issues. So it's true, all of this shows an intentional move to diffuse argument involving government overreach on private citizens as well as over state sovereignty. Now you see, those times were contentious, try to remember that for later, but this vagueness here, Congress will fix it. How it just listen, a statute was given. The title of this was the Judiciary Act. In 1789 it was written, providing specifics that were missing. No constitutional power is given to those in SCOTUS in particular. Federal courts and statute was set up, riding circuit for all minority ones who care about the circuit stuff. Oh, plus the number of justices that were stuffing in the SCOTUS bench. Here's a little nugget about the act that you may notice, friends. It didn't say nothing about how the court could overturn a thing or bring to government not its own that they went against the basic tenets of the Constitution. So it's intended to act as a check and balance to the branches of the president and our Congress too. The power to overrule those other branches wouldn't happen until 1803. The case was Marbury v. Madison. Think back a bit. Remember when I said those times were contentious? Well, here with the source of the little fight was an election for the president in 1800, and it was highly contested. You won by Jefferson. Power swung from the direction of the Federalists. Now the Republicans be running this government. The time will be coming quick. That's why the incumbent John Adams tried to stack the deck to make sure its offices were packed with Federalists. How many? As many feds as he can get before Jefferson could sit as president as evidence of Adams's intent. I give you John Marshall, a Federalist to the end. In 1801, before Jefferson got in, he was named Chief Justice of SCOTUS, but at the same time serving in Adams's cabinet. Secretary of State was the handle that he had back then, so it'd be plain to know who he would be backing, or so you would think. Adams's aim was clear, which he put on display just one day before Jefferson took his seat. Adams named the 40 justices of the peace, and he was all hurried to deliver his commissions. His mission was marred because they couldn't get him before Jefferson simply said no, buddy, and blocked all the commissions for people like Marbury, which didn't get delivered. Before he took office, the offense he's taking this begins a little contest. A writ of mandamus as Marbury commenced this case he filed to SCOTUS, hoping that if he wins, the Jefferson be forking over that old commission to author his opinion. And John Marshall, and remember that boy was in the position as the secretary. He was the one that signed the commission that he's ruling on as justice. What a conflict of interest, because he was backed by Adams with hope that he do his bidding. But it's hard here for Marshall, who's caught up in his political struggle with power in Republican hands. If they ruled against the president, they all would get canned, and it sucks just like a Hoover. He's stuck as to what to do here. His luck, he couldn't press him. My friends, he was up against the wall, no leverage and looking to find an exit from this no-win situation. He chose to split the baby and is holding on his writ of mandamus. First, saying something that today's relevant. The government of the U.S. is one of laws, not of men, meaning there's none above the law that goes for the president, just like it's all and it meant. For the law, a boy, William Marr, had a right to the commission, sure, but the court will not have the permission to rule on matters that per the Constitution, y'all, were left up to executive discretion. Political matters were left up to the president, and legal matters, well then we have a remedy. The court can rule to the extent the legal duties been eschewed. Body executive, like that we have a rule that's been established here. Judicial review, and Jefferson right here just breeds the duty of discretion. This isn't truly, and that they could review. See, next they will be moving to talk a jurisdiction of writs, though such as this one. The source of it was section 13, my friends of the Judiciary Act which the head official acts like this were meant to be heard in front of SCOTUS originally. The court would overturn that section no, because it didn't appear to be a power found in Article 3, which be not a floor of the court's power, it's a ceiling, you see. Congress cannot rise above it. If they do, then that means then that law can be enforced by constitutional means. And so Marshall struck down section 13. They can't be adding shit. Marshall said the court cannot handle this. They lack the jurisdiction for this case, so it can't exist. Although the acts by Jefferson per Marshall were bad, it's just nothing he could do, cause this suit ain't constitutional. This ruling by Judge Marshall was a move that was shrewd for show. He ruled for Jefferson and against the Federalists, while carving out new powers for the court, protecting it from being overrun by the other branches of the government. Republicans were loving it, but because they won, they didn't fight it. The Marshall justified it by writing the Constitution as limits the powers used by government. And without review, then those limits don't mean nothing. That's true. Plus it's the privates and the duties of the justices to interpret law and rule in cases that come under the U.S. Constitution. So who's the best to enforce those rules than those in SCOTUS? And basically, that's what they do.
Blah, blah, blah.